All right, guys, let's get into this story. This is a really crazy story, and I can't even believe the outcome. All right, guys, welcome back to another video. I have so many topics that I want to touch on that have happened recently within the last like 72 hours. One, of course, being the Menendez brothers' habeas corpus petition that they filed last year by their appellate attorneys. And this actually argued two pieces of evidence that were not presented during the brothers' two trials in the 1990s support their allegations of SA by their father. So that did happen. There were no cameras allowed in the courtroom, and no pool camera, no nothing. But I figured we would just go ahead, and I have not seen this at all. I do know the outcome of it, but let's watch this together.
For those who weren't in the courtroom today, I think you could talk to anybody who was. It was a very, it was first of all, the first time that Lyle and Eric have been at least remotely in a courtroom in a number of years, number one. It also was quite a moving experience, at least from where we sit, to listen to Aunt Terry and Aunt Joan, who are respectively Jose and Kitty's older sisters. Both made impassioned pleas with the judge to send the brothers home, and like I said, very moving. Terry testified under oath that she was very close to Jose and practically grew up with him, and Joan as well talked about Kitty and all of the good things that they've done since they've been in there. The judge has now set January 30th and 31st as the days for a plenary or fulsome hearing on the resentencing. He has also invoked what's called AB 600, so he has jurisdiction under that section as well, which is California law. He's going to and has heard and will ask for further briefing, and by January 30th or 31st, we're hoping that by the end of that, or sometime sooner, that we will in fact get the brothers released. The family is all here, and including Joan, who's here, who everybody can wish happy birthday to tomorrow.
Happy birthday.
And Terry, who is here.
Yes, where's Terry?
Where's Terry? Terry's in the back. Terry made the trip.
Bring Terry up here.
Bring Terry up as well. I will tell you that I did not program either one of them, and I don't think either one of them knew they were going to speak, but they spoke, and we did that so they could speak from the heart. And
we're sisters in kind.
yes, and you can tell them you want them home.
I do want them home. They should never have.
Can we get closer to the mic?
Closer to the mic?
What can a kid do with his father's?
Never happened.
I can't stand it.
35 years since that all.
It's time. Yeah.
Okay, thank you.
Oh, good. I can see the back of Mark's head.
I'm going to let the family go. I'll answer some questions as long as people don't assault the family on the way out of here, okay? Is that a deal, by the way? Yes? Okay, so let the family move out. And,
By the way, guys, this is Talia. This is Eric Menendez's stepdaughter. Slay, girl, because you know you look good.
yeah, please go back. Let them Create a walkway, please.
You're not family, you need to move back to me.
You already violated. Really? No deal. And I guess no questions if they're going to run after you.
Why are they doing this?
Oh, wait, Mark, can we ask you
Unless you stop that, then we're not
Mark,
doing
we
it.
got no bearing on them. They're rogue.
Mark, can we ask about the petition that was filed this morning, get rid of the special circumstance? Mark?
All right, so apparently the media has a frenzy and ends up following the family.
There you have it.
And so Mark's not going to answer any questions because. Okay. Okay, so what we got from this is we have we have a delayed resentencing to January 30th and the 31st, and a lot of people, when I was, what day did this happen? I think it was Monday. Let me check. I kept checking the news with any kind of update. What day was this? Why are you doing it? A day ago. Yeah, so it was Monday. And everyone was like, oh, bad news for the Menendez brothers, bad news. A delay is not necessarily bad news. So we will see what happens with that, but we're going to go ahead and move to our next. Let me mute my mic.
The fact that Miss Shaver, now Miss Filmer, has shown a total lack of remorse for her actions. I want to be clear that as far as any statements about that lack of remorse, especially from the PSI and the statements that I made, have nothing whatsoever to do with her expressing her innocence, maintaining her innocence, asking for a trial, asking for the jury to determine what the facts of this case are. That would be completely inappropriate and not an appropriate thing for the court to take into consideration for sentencing. When I talk about her lack of remorse, I refer to the actions that she took after her killing of her husband and all of the actions that she took to help cover that up. That includes lying to friends and family members, acting as if Michael Shaver was still alive, knowing full well what she had done. And those lies and manipulation extended not only to friends and family members of Michael Shaver, but his own children. That is, when I discuss her lack of remorse, that is what I am discussing, and that is something permissible for the court to consider her actions leading up to her arrest. Ms. Shaver is quite possibly the most manipulative defendant I have ever had charged with murder, and the extent that she went to cover her tracks deserved the harshest penalty, and I ask for life in prison on this case.
All right, thank you, sir. Mr. Wiggs.
Yes, Judge. I'll just briefly summarize some of the evidence, ask the court to consider such evidence that the court heard before it throughout the trial. I point out to the court that Ms. Shaver was not convicted of an accessory, as the state may allude to, but we heard evidence in this manner. There was digital evidence that was presented by the state. In advance of trial, I'd moved to exclude the digital data inasmuch as Facebook did not have any connective links as to the evidence, could not be linked to an IP address, a user, a location, or a device. Likewise, there was no business record certificate.
She got a jawline again, guys. Look at that.
Instead, they just simply
She got a little bit of a jawline.
did not exist
All right.
at this time. Despite that, the court allowed such evidence. Likewise, there was, aside from a lack of a connective link between Laurie Shaver and any physical evidence, what seemed to be the body of the state's case, there was a couple cards that were testified to. Defense counsel moved to exclude that, claiming that there was no handwriting analysis that had been conducted, and I think that's Proctor. That was in my motion, and nobody that could testify as to the authentication of the handwriting. That was read into evidence by a witness, wasn't simply ushered into evidence, but was read into evidence. And that had no connective link offered during the trial to Laurie Shaver. Likewise, there was reference to a sale of guns. Not one single gun that the state elicited testimony about had any actual involvement in the crime itself. I'd filed a pretrial motion on that to exclude it, and I think the relevant case was a case, I believe it was Agathis, that should be excluded. A case was appealed and reversed on that same basis itself. There was a gun that was actually entered into evidence by the state. The expert claiming that it had no connective link, it was just the type of gun. It had characteristics of the gun. No different than taking a picture of a white man or a black person leaving the scene of a crime and say he was this color. That was the connective link that the state relied upon. It had no probative value in this matter. Simply offered as prejudicial impact. The court will remember there was no connective link between the gravesite and Laurie Shaver.
This has nothing to do with the case, but I did not notice until today that he had like some kind of major surgery on his skull at some point. It's like, holy shit. I did not notice that during the trial at all. But then again, he was never at this angle. Wonder what happened. I may look it up. If I find out, I'll let you know.
No DNA. There was no any clothing, anything that had a connective link to Laurie Shaver in the form of DNA, hair samples, or anything in that matter. The state, you may recall, tried to downplay this. I think it was Mr. Buxman questioning the witness saying, well, you're not surprised that there's no link between that given the degraded condition of the straps that were found in the grave. Ignoring the fact that possibly there was no connective link, being there was never at any time any DNA or evidence on those straps. The same way with the tarp. There was a blue tarp. Reminded the court that I brought out on cross-examination. The state did not take it upon themselves to do any kind of forensic analysis to see who, if anybody, had purchased that tarp. Nor did they do any DNA analysis on that tarp to see if it had been drug across the ground or how it got to the gravesite. I would bring that to the attention of the court. There was also testimony, unrefuted, from the medical examiner that there were buccal swabs connected to Michael Shaver, which indicated that there had been some force or trauma at a point post-death or after the death of Michael Shaver. It was testified, and the court heard testimony that the boyfriend at that time, Mr. Townsend, had, they believe, removed the body only to return it later. There was no evidence that Laurie Shaver had moved the body, and that could not be accounted for. That was brought out in evidence. It was likewise objected to throughout the trial continuously as to the form of the introduction by the state. I brought to the attention of the court that the state entirely relied on circumstantial claims of evidence, and that would be, it was always everything the state declared was going to be a timeline link, anything that came into evidence, whether it was the gun, whether it was the sale of guns, whatever it was, that would be their claim. I presented to the court a case, Smith versus Carlisle, which went back through the history of circumstantial evidence and reinstated a case called Volcker. And there the Supreme Court had declared if the state's going to rely on circumstantial evidence, there must be a foundation for that evidence that's not subject to any other reasonable interpretation except that of guilt. At no time did the state throughout this trial, not one single time, did they establish any foundation upon which these circumstantial claims were based. And that instead...
Yeah, maybe I lied. Maybe it wasn't the victim impact statement. Maybe it was his fucking ass dragging. Any chance he gets, he's gonna still pretend like she didn't get handed down the verdict. She got handed down. He drives me insane. And I do believe that they love each other.
They argued to the jury in their closing it was just a totality of these circumstances that they could hang their verdict upon. Now, we understand there's a minimum mandatory of 25 years in this case, Judge, and the court can impose a life sentence in this case. Based on the evidence, the undisputed facts as I've just brought to the attention of the court, we'd ask for the minimum mandatory of 25 years be imposed against Laurie Shaver. That would be our recommendation to the court at this stage. And Ms. Shaver, I know in the PSI she had sent the court a letter as to her feelings, impressions, and her sentiment about the matter. I presume it's made a part of the record for the purposes of the sentencing. And I sympathize with the family that's here. I know they have heartfelt feelings about it and emotions. It's not testimony in the sense that it's offered anything to establish the state's case. And I am sympathetic as to the scenario that they found themselves. The court would be reminded, though, and also in this case, that there was evidence of physical abuse by Mr. Shaver. And there was nothing that really contradicted that in this trial. I bring that to the attention of the court as well. And I think all these facts would justify at least the minimum mandatory imposition.
All right. Does your client wish to address the court?
Do you need 1 second? Okay. No, she doesn't, Judge.
Okay. Is there anything further?
Nothing further from the defense.
Anything further from the state?
No, sir.
Please present your client for sentencing.
Shaver.
All right. Laurie Shaver Filmer, in case number 2020 CF 2361, having been found guilty by a jury of your peers of the offense of murder in the second degree with a firearm and having been adjudicated guilty of the offense of murder in the second degree with a firearm, the court hereby sentences you to a term of life in the Florida Department of Corrections. Standard fines, fees, and costs will be assessed. Mandatory court costs will be assessed. You will have 30 days to appeal. Do you wish to have appellate counsel appointed?
Yes, Judge, and I've prepared motions for the court. At this stage, I filed 2 notices of appeal. The clerk sent one prematurely to the DCA, and it got returned. I advised them that the state had inadvertently sent it in advance of the sentencing. So that was returned yesterday. I filed was dated or identified as a second notice of appeal, and I've sent the clerk a letter, wait to the sentencing to send this. I've likewise filed with the court a motion for appointment of declare the defendant indigent for costs and to request that the public defender's office be appointed. The JAC has received the pleading. They said they have no input on the matter, and they've been noticed for the hearing as well.
All right. State have any objection?
No.
Okay. Well, the court will appoint appellate counsel for Miss Laurie Shaver Filmer.
Very well.
All right. Do you have a proposed order?
I'm sorry. Yeah, I have a proposed order, if I may.
Madam Clerk has an order, Mr. Wiggs, so we'll use the order that Madam Clerk has prepared.
And Your
Is there
Honor,
anything further from the state?
just real briefly, as a matter, when you refer to the standard costs, that would include the $100 cost of prosecution.
Yes, $100 cost of prosecution will be imposed.
Thanks, sir.
Judge, one thing, and I know it's not
Brother.
on
My lord. I think that I think he's doing this case pro bono. I'm gonna look it up. Pretty sure, because remember when I first presented this case, did I link or show her? I can't remember. Their little like YouTube intro video from like 5 years ago or something. And he's like, I'm doing this for free. So if you want to help us out, bro, above and beyond. And now she'll no longer have him because she will be referred to appellate attorneys, which is not him. So, will their love affair continue? Do you guys think that she's in love with him, or he's in love with her, and that's why he's fighting so hard? Why is my camera blurring right now? Or am I having a stroke? There we go. Focused. All right, let's finish it. Let's finish it.
DOC, but the court can state in an input that as to placement, Ms. Filmer at this stage has requested that the court recommend placement at the Gadsden facility in North Florida for family visitation at this stage.
State have any objection?
No, that's completely up to the Department of Corrections.
And again, that is up to the discretion of the Department of Corrections. The court can.
All right, let's look that up. She got life, by the way. And she will die in jail or prison. She's not getting out. She's already in her 40s, I think. Can't remember. Okay. Gadsden volunteer. It's crazy. Okay, so adult or youthful. Oh, it's all female, obviously. Looks like they got some programs, some services. Oh, they got a teddy bear club. Wow. What does one do in a teddy bear club? So, this will be the home of Laurie. If this is a request, who knows if that will actually happen. Oh wow. School or prison? Man, I want to work at a prison so bad. All right. So she got life. Let's look at this. Oh my God. Oof. Oh my God. That gives me such anxiety. Keep things going. We had a hearing with Karen Reed today. And from what I heard, okay, this is discovery hearing, another one. God, guys, does this feel like it's literally like deja vu? All I know so far. Okay, so I'm going to briefly read what I have researched thus far on today's hearing. I did catch Laurie, live. So basically, it was a discovery hearing, and the Commonwealth is trying to they want the Karen Reed's parents' phones. The discovery hearing at Norfolk Superior Court touched upon several motions and pieces of evidence that would impact Reed's new trial. Prosecutors have requested phone records from Reed's mother and father, saying that they want records to establish Reed's regular patterns of calls with her parents. And this is because apparently Karen called both of her parents around 1:30 a.m. the day of that John O'Keefe was found dead. Obviously, this is another fishing expedition that we all are so very used to when it comes to this case in general. But also, the Commonwealth is also seeking materials from several media outlets, including Boston Magazine. Basically, everything that Karen interviewed with, any articles, any interviews, they're trying to establish that Reed has made contradictory statements in media interviews. And that's all I know so far. So let's go ahead and watch this.
You may be seated. There's 22-117 Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura McCall.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCall.
Good morning, Your Honor. Elizabeth Little appearing on behalf of Defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning.
If you guys don't remember, Jackson is not at this hearing. But this is apparently the only one he's going to miss, if I remember correctly.
Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears.
Mr. Jackson is there, and he is through, like, you know, FaceTime, whatever, Zumba.
Okay, we can't see him now, Jim?
Yeah, we can't see you. Is that okay?
That's correct. All right. Good morning, Mr. Jackson. All right. We have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Mr. Unetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer. Criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay. All right. Thank you. All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days, to begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. No. There were 2 search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Miss Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment.
Is he a doctor now? What the fuck?
And my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. Have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting of her records. And so that...
All right, Hank Brennan, the new addition to the Commonwealth's team of prosecutors, articulately laying out the reason he wants those phone records from mom and dad. We're going to break, get you back into the courtroom, pick it up where we left off. Stay with us.
I hit him, I hit him, I hit him, I hit him.
Karen Reed is innocent.
We find ourselves deeply divided by fundamental differences in our opinions and state of mind.
We stand for the O'Keefe family. We stand for John O'Keefe. This is an abomination what's happening.
No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Karen Reed back in court this morning in Massachusetts for a pretrial motions hearing. The hearing is about evidence in her upcoming trial, and they're focusing on the parents. The parents' phone, Karen Reed's parents' phones. The Commonwealth wants phone records from mom and dad. Let's go back into the courtroom and pick up the argument from the state right where we left off.
Stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor. Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information from Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at C.F. McCarthy's. And he wasn't present at the Waterfall on January 29, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon.
Thanks so much for watching, and if you enjoyed this video, please like, subscribe, and share with some friends.